Okay, next we have our next panel, which is on recovered memories, and I will be introducing Sangeeta Sinha. Before we do that, I wanted to acknowledge Sheriff Ross Mirakarimi, who is here. Thank you very much for being here, Sheriff. And also Captain Jason Fox, who's here on behalf of the San Francisco Police Department. So our next panel is Beyond Woody Allen, Can We Trust Our Memories? And so with great pleasure, I introduce Sangeeta Sinha, who's one of the felony deputy public defenders and is going to moderate the discussion. Ask all the panelists to come up and take their seats.
So, good morning, everyone. Thank you for coming. I'm very excited to be moderating this panel on memory. Back in February, the nation watched as public allegations of child molestation flew back and forth between Woody Allen and the director's former and current family members. Allen's adult daughter, Dylan, claimed that her father sexually abused her in the attic of their summer home when she was 7 years old. Woody Allen said that Dylan's mother, Mia Farrow, had implanted false memories of child abuse into Dylan's mind during a particularly acrimonious child custody dispute. Last week, memory was again at the center of another public allegation after a 31-year-old man sued X-Men director Bryan Singer for allegedly sexually assaulting him at a party in 1988. The alleged victim told the press that he blocked the incident for years and numbed himself with alcohol, but that his memory resurfaced when he became sober and started therapy. So, who's right? How fragile and malleable are our memories? And what does that mean for abuse victims and their desire for justice? What does it mean for the accused and their rights? Our first panel, Beyond Woody Allen, attempts to answer a very simple but vexing question. Can we trust our memories?
This morning, we're starting to get some responses from celebrities to a dramatic and really disturbing open letter penned by Woody Allen's daughter.
Yeah, her accusations of abuse at the hands of the filmmaker date back 2 decades, and now she's questioning why Hollywood has turned a blind eye.
A conviction requires proof beyond a reasonable doubt. So what if the only evidence is an old memory? In recent years, science has illuminated much of the mystery surrounding memories. A new consensus is emerging among cognitive scientists. Rather than possessing fixed, unchanging memories, they have found that we create recollections anew each time we are called upon to remember.
One thing we know about memory is it doesn't work like a videotape recorder. You don't just record the event and play it back later, but rather it's malleable and it's susceptible to distortion, contamination, and other influences.
In 2002, a Boston priest became, as some reports put it, the most hated man in Massachusetts. Defrocked priest Paul Shanley now resides in a US jail, convicted of serially raping a young boy. But is it possible his accuser remembers in vivid detail something that never happened?
The story and all the facts, to me, look like there's a very real chance that there could be a false memory.
Oh, my God. I had no doubt that the vast majority of what he remembered was accurate.
Even more controversial is the concept of repressed memories, in which people reportedly block out traumatic events only to have them resurface years later. Controversy surrounding these recovered memories, sometimes referred to as the memory wars, came to a head in the 1990s after several highly publicized false convictions. Today, the existence of repressed memories remains a topic of debate among psychologists, with some studies concluding they may occur while other studies dispute it. And while some people may wish to pursue these memories through therapy, do they have a place in the courtroom?
When I got into the memory wars, which was about the early 1990s, I thought, well, maybe there is some evidence for massive repression of horrific brutalization. And when I began to delve into the literature, I was really pretty shocked to find there really wasn't any credible scientific support for this.
And that view hasn't changed. She cites a multi-study analysis of 11,000 victims of torture and other major trauma, where not one case of memory repression was found.
I don't really think we ought to be throwing people into prison based on a flimsy theory, no matter how logical the theory might sound to somebody.
So it is with great pleasure that I introduce our panelists today. Dr. Melina Uncapher is a Stanford and University of California trained neuroscientist with over a decade of experience in conducting field-leading neuroimaging research on how humans learn and remember and how they pay attention to the world. Since 2010, she's conducted applied neuroscience research at Stanford University, funded by the MacArthur Foundation and the National Institute of Health. Her work guides lawmakers in evidence-based practices for memory-related issues in the criminal justice system, such as whether neuroimaging technology can determine whether an eyewitness is accurately or falsely recognizing a witness, or whether it can detect concealed memories. Jim Hammer is a highly experienced lawyer with extensive trial experience in complex cases. Jim spent most of his early career as a prosecutor, culminating in his work as the head of the homicide division of the San Francisco District Attorney's Office. While there, Jim prosecuted a variety of complex homicide cases, including securing the first murder conviction in a dog attack in the case of People versus Noel and Noller. In recent years, Jim has successfully represented clients in a variety of civil rights cases. Joey Piscitelli is the North California Director for SNAP, the Survivors Network of Those Abused by Priests, and since 2001, he has advocated for more than 600 survivors of child sexual abuse. In 1969 to 1970, at the age of 13, Joey was routinely molested by a priest at his Catholic school. Joey is the only clergy sex abuse victim to have ever gone to a court jury trial against the Catholic Church in Contra Costa County. He won that trial in 2006 and has since prevailed in 3 appeals by the church, despite being accused by church lawyers of having false memories of the crime. And finally, we have Doug Horngrad, a longtime criminal defense attorney whose former client was wrongly convicted in 1980 of murdering an 8-year-old girl. The conviction was based largely on a witness's buried memory of the crime, which resurfaced due to hypnosis. The client served more than 6 years in prison before being released, and the landmark case ushered in a new era of skepticism surrounding claims based upon repressed memory. So I'd like to say thank you to all of our panelists. If you have questions, there are cards. You can write your questions on the card and pass them to the center aisle here, and they'll be picked up by one of the ushers. You can do that throughout the presentation. So, to start with you, Dr. Uncapher, there seems to be a concept that you can close your eyes and relive a memory just as it happened, much like watching a video. Is that a correct concept?
It's actually a very incorrect concept, and there's multiple components that go into that. And the main thing is that memory is actually very constructive as well as reconstructive. So what that means is that the different components of your memory are stored in different parts of your brain. So the part of your brain that's storing the sound of my voice right now is different from that that's allowing you to store the thoughts that you're thinking about right now, or the feelings that you're having, the things that you're seeing. And in order to put that into a memory for this event, it needs to be labeled, but they're all in different parts of your brain. So when you retrieve this memory later, let's say someone asks you tomorrow to remember what the panelists said, you actually need to go into different parts of your brain to bring a full memory back to mind. And so that process of reconstructing the memory is very prone to error. And what happens is you don't bring all of it back to mind. Sometimes you bring different things back to mind, and sometimes they're very, very distorted. And the other piece of that is that our memories are not just records of the events itself. Our memories are records of our experience of the event. So that's very contingent on how you experience the event. So if you don't pay attention to something during the event, there's no amount of hypnosis or imagery or anything that will allow you to recover that information later if it just was not recorded. And the last piece is that there's a very different concept of how we judge the truthfulness of a memory. So we think that if someone tells us a memory and they're really confident about it, that must mean that that memory is true. And that's just not the case. Likewise, if the memory is very detailed, that must be true. And that's not the case. And also, if somebody tells us a memory that's very emotional, we think that that means it must be true. But again, that's not the case. It doesn't mean that it isn't true. It just means that confidence and detail and emotion don't actually indicate how truthful a memory is.
So Joey, in your trial, you were accused of having false memories. Could you tell us about that experience and maybe a little bit about how you were able to demonstrate to the jury that your memories were in fact true?
I think the best way to demonstrate to somebody that you're telling the truth, whether it's about sex abuse or anything, is just to recall it exactly the way it happened. Don't add to it, don't subtract from it, be consistent. And in my case, and a little bit contrary to what she said, I remember each case of being molested by the priest. The best way I can remember it is I actually do watch what I think is a video in my head. And I go through the scene and I narrate it as it happened. When he walked into the room, what he did to me, as he did it. I look at the wall with the cross on the wall and I wonder why God didn't do anything while he was molesting me. I look at the door, I look at the window. I see all that in the memory and I narrate it. And that's what I did with the jury, and they believed me.
Doug, what do you think? Do you think recovered memories have a place as evidence in the court system?
Well, the lesson that we learned in the Franklin case was that it's very dangerous to have a trial based on a memory alone, particularly one that's claimed to have been repressed, without any corroborating evidence.
Could you tell us about the Franklin case?
Sure. It was actually in 1989 or 1990, and George Franklin was arrested in San Mateo County for having killed his daughter's friend 20 years earlier. And his daughter had come forward indirectly through several other people and claimed that she had just remembered seeing her father kill her best friend 20 years earlier, in 1969, a girl by the name of Susan Nason. And based on Eileen's recovered memory, which she described as a recovered or repressed memory, Franklin was prosecuted for that murder. And at the end of the day, the only testimony that implicated George in that murder was Eileen, that's his daughter's name, Eileen Franklin's testimony. And When I first met him in jail, we just knew it was an old murder case, and I'd seen in the newspaper that morning that his daughter was accusing him of a repressed memory, having repressed his murder 20 years earlier. It was going to obviously get a lot of media coverage, which it did. And I ran down to the jail to tell George, hey, this is why you're here. You're here because your daughter said she remembered seeing you kill her best friend. And the daughter's name was Eileen. He had several daughters, several kids. When I told him this, George looked at me and said, Janice? Well, Janice is the one he got along with very badly for many reasons. And from the first moment I met him, I thought, well, gee, if you did a murder and your daughter was with you, you'd remember which daughter it was. So in the privacy of that cell, I immediately thought, boy, this guy's not good for this crime. Something bad is happening here. So the case went to trial, and there was a lot of manipulation by the prosecutor, a lot of manipulation of evidence. For example, they arranged a jail visit for the daughter to see him, acted as their agent, which is not legally permissible. But most importantly, at trial, and there was sort of a hysteria about it. It was kind of the crime du jour, the theory du jour. It was the first case in a criminal prosecution with a repressed memory. That had earlier been a civil case, Gary Ramona up in Napa, but George was the first criminal case. And everything that Eileen, all the facts that Eileen claimed to know in detail, the victim had a ring that was crushed and she was killed by a rock and so forth. Everything Eileen knew had been in the public domain. We dug up all the old newspaper articles and TV clips and all this. And there was nothing that Eileen testified to that hadn't been known back in 1969. And in fact, her husband said he was collecting the newspaper articles about the case, and Eileen said, but gee, I never looked at those articles. In any event, the trial judge would not permit us to put in the evidence of what had been in the newspaper articles. The prosecutor moved to suppress that evidence. So when Eileen said, well, there was a lot of clutter where her body was left, that was in the newspaper and the TV coverage. Well, she got hit by a rock and there was a rock left nearby her body. That, of course, was in the newspaper articles. She had a ring on her finger that was crushed. That was in the newspaper articles. Everything she testified to had been in the public domain, but the court would not let the jury hear that. So prosecutor got up in closing argument and argued the absence of evidence that she suppressed. In other words, she got up and she said, well, how could Eileen know all these things if she wasn't there? Couldn't possibly know these facts if she wasn't an eyewitness. And that was the sleight of hand that got Franklin convicted. And because it was a trendy concept, and the case went up to the, and because of who was on the California Supreme Court and the courts of appeal at the time, that case just went through the system like a hot knife through butter, 3-0. Unanimously, the Court of Appeal upheld the conviction. Supreme Court upheld the conviction, said that her testimony was very convincing. And finally, it got into federal court and was heard by Lowell Jensen, who still sits from time to time in the Northern District in the Oakland courthouse. Lowell Jensen had been the deputy district attorney in Alameda County under Ed Meese. Those of you old enough to remember the Reagan years, if you care to. And Ed Meese was Ronald Reagan's attorney general, and Lowell Jensen was a #2 guy in the Ed Meese Justice Department, which is to say he was no flaming liberal, he was no Rose Bird. He was a deeply conservative, lifetime prosecutor, and eventually was named to the federal bench. And Jensen got hold of the case, and he wrote an opinion essentially tearing that case to smithereens and reversed it, the conviction, on a half-dozen different grounds, primarily on the ground that the defense did not have the opportunity to put on evidence to rebut the so-called recovered memory and to test its reliability. And so the case came back. And interestingly enough, after Jensen reversed the case, Eileen came forward and said, oh, gee, I remember another murder now. Now that murder number 1 was in jeopardy. Murder number 2, she suddenly recalled. And the police were very eager to find that murder. So they looked all over to try and find facts that in some way were consistent with what Eileen was describing. And they found a murder down in Sharp Park where a woman had been killed. And they showed Eileen the pictures of the scene and the victim, and she said, oh my gosh, that's the scene. That's the girl. That's murder number 2. You found it. And George had been a firefighter, and so he was active in the union, in the AFL. And it turned out that when the police had Eileen ID this scene, they had known that George had not been at work that day, signed out early. And they thought, oh boy, now we got him because he's not at work. And Eileen says, this is the killing, and hardy har har, here comes murder number 2, just in case we have trouble with murder number 1. And, but as it happened, George was at an AFL meeting, and they still had the records of that 20 years later. So he had a stone-cold alibi. Well, we sat on that information for a while as trial number 2 was ramping up. And we had claimed in trial that we believed Eileen had been hypnotized to get this memory back. She had told that to several family members, and then she said, well, I lied because I was embarrassed about just getting it recovered. In any event, just before the trial was about to begin, her sister, Janice, who was a witness for the prosecution, called the prosecutor and left a memorable voice message and said, which we were given, where she said, well, Marty, we lied in the first trial, Eileen and I. We were hypnotized. And we were both hypnotized to get these memories, and we were told that hypnotically induced testimony is not admissible in the state of California, which is a true statement of law under People versus Shirley, and so we lied about it. And the therapist who testified at trial, a guy by the name of Barrett, he lied too, because he was a guy who hypnotized us. And so everybody denying at a trial, we all lied about that. So Judge Schwartz, who now sits in the city from time to time, had an evidentiary hearing. All this came out. And then we decided to tell the prosecutor about the stone-cold alibi for murder number 2. And so the following week, the case was dismissed, and Franklin was freed from prison after having served 5+ years based on the allegation of repressed memory only. So the lesson in Franklin, we believe, is that if someone's going to come forward and claim a repressed memory, no defendant should ever be convicted based on that testimony alone. If there's going to be a claim of a repressed memory or a forgotten memory, there has to be corroboration. That really was the gist of Jensen's opinion. And I've had a lot of people contact me over the years who've been accused by family members of molest and things like this. And what I'm understanding from their experiences is that prosecutors will not try to, and Jim can tell us more about this, but prosecutors will not try to prosecute a case unless there is some form of corroboration, because otherwise you run the risk of locking up an innocent guy or woman for the rest of their life. So that was the Franklin case.
So Jim, as a former prosecutor, what do you think?
Well, the case of repressed memories that Doug talked about are frankly a nightmare. For anybody who enters a career as a prosecutor or as a police officer, an investigator, our worst nightmare too is sending the wrong person to prison, convicting the wrong person. And I find in some of the more horrific cases that I've encountered, read about, or seen, it's sometimes when prosecutors didn't do their job, because I think that's the first line of defense against wrongful convictions, is ethical prosecutors who aren't just trying to get a conviction, but are trying to do justice in every single case. Same with police officers. Every memory has some of the same features Doug talked about and Melina talked about, meaning it's not truly a videotape. Unfortunately, crimes aren't committed in front of surveillance cameras, so we can't replay the crime and say, now vote, guilty or not guilty. The truth is criminals intentionally pick out victims when they're alone, often. Rapes are not committed in front of 4 witnesses. Child molestations are often done in secret. And so every prosecutor's hope and search is for some corroboration. Every investigator's search is for the same thing. But some tough cases were stuck sometimes with nothing but an eyewitness testimony. And that's the kind of case that keeps a prosecutor awake at night. Because again, there's always the possibility in a case that you're going to get a wrong conviction. You have the wrong person. If you have the wrong person, you put the wrong person in prison, and the right person is still out offending. So it's really a very dangerous thing. And so I think the first line of defense, and really the first most important thing to do, is for investigators and prosecutors to look very critically at eyewitness testimony. One of the most important things is to do it with an open mind versus a closed mind. So there's a temptation to try to build up the witness, since that's your only witness, in ways that will help the conviction. And that's a huge mistake, but it's a trap you can easily fall into. So as opposed to trying to avoid weaknesses in the identification or simply trying to buttress it, it's incredibly important very early on from the first steps to ask open-ended questions, to really figure out what are the weaknesses in that, and then ask yourself, because you can't punt to the jury, that's not ethical, do I believe there's proof beyond a reasonable doubt? Because if I don't, then I need to dismiss that case. I have examples we can talk about later, but I think that's the first line of defense against this problem.
Well, Dr. Uncapher, we've heard from Doug and from Jim testimony that has been enhanced or memories that have been gleaned through hypnosis is inadmissible in court. Is there any research on whether you can implant memories in someone else so that they have a memory of something that they never experienced?
Absolutely. There's actually about 30 years of research, so obviously I won't go into all of it, but some of the seminal work has been done by Dr. Beth Loftus, and she has shown that you can implant false memories in many different ways, some of which are very kind of minor false memories. So she could implant a memory such that one of you could remember that you'd been food poisoned as a kid by hard-boiled eggs, and then can show that your preference for hard-boiled eggs now decreases, so it actually has impact on behavior. She's also shown some more, I think, horrific false memories that can be implanted. She's shown that she can implant memories of being molested by, or not molested, but touched inappropriately by Pluto at Disneyland. That's a pretty emotional false memory. The methods have all been reviewed by institutional ethics boards. So, but you can also do more real-world and stressful memory misidentifications as well. So she studied 500 highly trained military personnel who are going through a POW camp, a mock POW camp, and had been interrogated face-to-face for 45 minutes, and showed that 2/3 of these highly trained military personnel misidentified their interrogator, despite having full view of their interrogator for 45 minutes. So there's lots and lots of possibility, and you can do it in multiple ways. You can do it through hypnosis, you can do it through guided imagery. So you can, as a therapist, you could say, well, you seem to have symptoms of someone who was sexually abused as a child. So where do you think that might have happened? Or who do you think that might have been at the hands of? You can also doctor photographs. You can tell people about other people's memories, and then you start to take those memories on as your own. I think one of the most relevant studies is one showing that 26% of jurors actually will remember details about court proceedings that never happened, that were never introduced into the proceedings, but were just implied based on leading questions by the attorneys. Also, 15% of jurors will remember details that were never included based simply because they fit the description of a typical crime scene. So there's all sorts of ways that our memories can be distorted and implanted, and it's quite surprising.
So, Joey, in your work then with survivors who are sometimes forced to rely on very old or sometimes recovered memories, what are the challenges in trying to get justice for those survivors?
I think the biggest challenge for survivors of sex abuse is probably a good example of it is going on right here at this table. There seems to be this view in society now that's kind of on the bandwagon, that there's this epidemic of false memory. I think everybody out there who's looking at me right now would maybe agree with me that if somebody was in the room with you right now sexually molesting you or raping you, and you're looking at that person and you're experiencing that it probably would stick in your mind and you would remember it. The danger of throwing this blanket theory that a lot of kids or adults who were raped and molested as kids, the danger in throwing this blanket theory of false memory out there is that you're discouraging a lot of kids and molestation victims, people that were raped, you're discouraging them from coming forward. Right now, only about 1 out of 3 women who are raped come forward. Only about 1 out of 9 kids who have been molested or raped come forward. When you feed this frenzy that there's false memory epidemic going on, you're making society more dysfunctional because a lot more kids are less likely to come forward. And society suffers from that. Nobody wins from that. The justice system suffers because of that. Society suffers from that. And it costs billions and billions and billions of dollars in healthcare costs for the after effects and the aftermath of people being sexually abused. I think everybody here knows that. Whether you're a defender or prosecutor or whoever you are, you know that the healthcare costs involved in unreported sex crimes, especially of kids, costs us all a tremendous amount of money. So watching the thing about Woody Allen's daughter or whatever, and everybody labeling her as a liar and saying there's this epidemic of false memory is just hurting us all. There is no epidemic of false memory. What there is an epidemic of sex abuse and child abuse, and we all suffer because of that. If 1 out of 4 girls reports being sexually abused, only 1 out of 4, there's people looking at me right now that were sexually abused that never reported it. And whoever you are out there, you're probably looking at me now saying, that happened to me and I never reported it. And so I think that we all would benefit from not throwing this blanket theory at everybody who comes forward and said, I was sexually abused or I was raped, and label them as a liar. I think we'd all benefit from that.
Doug, Jim, would you agree? Disagree?
I agree with Joey. There is not an epidemic of false memories in my view, in my experience, 25 years as a lawyer. There is an epidemic of sexual assault, of rape, of child abuse. So I totally agree with you, Joey. I think the case that Doug talked about is an extraordinarily rare one, but an important one. But extraordinarily rare, I've never, in all the cases I prosecuted, investigated, and never encountered it. What I was addressing, and I want to give one example, is memory. That is, when you rely on an eyewitness, it can be very problematic. I'll give you a quick story. When I was a prosecutor in Santa Clara County, I was assigned a case, a handoff that was about to go to trial. The guy was charged with felony drunk driving, meaning somebody had been very seriously injured in this accident. I was assigned a really good investigator. He said, let's go check out the scene. So we went out and literally went to where the crash was. This truck had gone airborne, hit a fence, and the top railing of the fence literally impaled through the windshield. Literally, it's a miracle it didn't kill the person who was hit, and that was the nature of the felony charge. So we started looking at the police report, the photos, and the scene. There's only one problem. It was clear whoever was driving the car was the guy impaled by the railing on top of the fence, because that's where the windshield was pierced. The defendant, who was ready to plead guilty, didn't have any chest wound. The chief prosecution witness had a chest wound. We had the wrong guy. Within a day or so, I knew that. I called the defense attorney, tried to get him down to the courthouse on a Friday to release his client on bail, and he said he was busy. I swear to God. So Monday, when he finally came for our next appearance, I laid out the evidence to him. And I said, can I talk to your client? And he said, sure. He says he's guilty. So I sat in an interview room, in a jury room with the client, and I said, listen, you're about to plead guilty. I don't think you did it. Why are you saying this? And he said, he went through what happened that day, and he said, my friend, the chief prosecutor witness, said I was behind the wheel. And I said, what's your last memory? He said, well, I was in the bed of the pickup truck. But my friend said I was driving. He, on some level, believed he was driving. The evidence 100% said he wasn't. I dismissed the case that day. He walked free and then prosecuted the real culprit for perjury and felony drunk driving. He was convicted of both counts. So there's a case of memory. A defendant would have walked in and pled guilty because of a good police officer and a good prosecutor, not his defense attorney. We were able to undo it and get the right guy. So what I'm talking about, in every memory case, every eyewitness case, you have an affirmative duty to dig, to really ask the hard questions, not just to say, well, that's what the evidence is, we'll let the defense attorney do that.
Well, let me just make a distinction, if I may, between what Joey and Jim were talking about and what the Franklin case was about. False memory and challenging memories, every case is about memory at the end of the day. Every trial is about memory. And the point is that memories have to be tested. The Franklin case was a repressed memory case. It's very different than what these folks are talking about, where someone says, well, I had something happen to me that was so traumatic and so awful that I drove it entirely from my mind. And now, 20 years later, I remember it. And in fact, in Eileen Franklin's case, she said there were rapes and a couple of murders that she witnessed, and her godfather raped her with her father helping her, and just on and on and on, of stories that she had, memories that she had repressed and then suddenly remembered. And the problem is with repressed memories, very different than what these folks are talking about. But the problem with repressed memories is they have a dreamlike quality. And the perspective floats, and certain details are blown up, and there are motivational anomalies, and therapists are here to say, there, what a bad thing that's happened to you, let's help draw this out of you. Like the therapist did in the Franklin case, he hypnotized her to draw this out of her. And so that's a very dangerous game when you're talking about a repressed memory. And it's a very dangerous game when you're talking about convicting someone and sentencing them to life in prison based on a repressed memory only. All cases are about memory, but the Franklin case was about repressed memory, and there's a big difference.
Can I respond to that?
Absolutely.
The last case I know in California of repressed memory was in Stockton 2 years ago this week. Father Michael Kelly was accused by an Iraqi veteran who had a repressed memory, who said, I remember now that Father Michael Kelly molested me as a child. Everybody at the church, on the internet, the media, everybody said this guy was imagining this, and he's a vet, and he's damaged, and it was a repressed memory case. Anyway, it was set to go to trial. While it went to trial, I don't think there was corroborating evidence at that time. He was on his own, and he was thrashed and mutilated and dismembered on the stand by everybody, like I was when I went to court. And what had happened was, after everything was said and done, the jury believed his story. And Father Michael Kelly was found wrong. And then the jury was set to do a second phase of that to determine how much the plaintiff was going to get for that. At that time, Father Michael Kelly bolted and took off to Ireland. In the meantime, I myself got calls from 2 more victims of Father Michael Kelly. And then other people came forward. Right now, I think there's a total of 6 or 8 people that have come forward, all saying they were molested by this same priest. There's a federal warrant out now for his arrest. He's hiding somewhere. And since that case, there's been a ton of corroborating evidence, all from people at different times in different places, molested and raped by the same person. So I'm going to say that I think, based on all that corroborating evidence, that I think that it's probably true that Father Michael Kelly did, in fact, molest this guy who had the repressed memory. And that happened 2 years ago.
Well, I think in a sense that makes a point that I'm trying to make. The trial that you just described to us was a civil trial, which has a different burden of proof, and a civil trial is about money, and it's not about liberty. And so it sounds as if when that civil trial was going forward, there was no criminal case against Kelly. Now you tell us that you've read that there's corroboration against Kelly. Well, then now there's a criminal case. So there was properly, if I'm understanding the story correctly, there was properly no criminal case against Kelly, a civil case with a much lower burden of proof, until there was corroboration. And then when there was corroboration, then apparently some prosecutor thought there was enough evidence to go forward. That's the difference, corroboration.
Yeah, but what I'm saying, there was no corroboration first, but now, after the fact, there's tons of corroborating evidence. So does that, in your mind, do you think that the first person who came forward that said he raped me and molested me, do you think his repressed memory was accurate?
I think that if that case went to trial with that state of the evidence in a criminal courtroom, the proper verdict would be not guilty. I think that if the case then goes to trial in a criminal courtroom and there is corroboration, then certainly a proper verdict there could be guilty.
We have a question from the audience. Anybody on the panel can take it. It says, what is a repressed memory? What about a memory that has always been there but is only articulated at a later time? Is that considered repressed?
I don't think in the general definition that we as society use it. Memory researchers tend not to use the word repressed memory because there's not much evidence in support of it. It doesn't mean it doesn't happen. It just means we don't have much evidence in support of it. There is a lot of evidence to suggest that a traumatic memory is generally a stronger memory than a neutral memory, and stronger memories are hard to forget. It doesn't mean they can't be forgotten, they can't be not attended to, it just means that they tend not to be forgotten. And I think the way that our society writ large uses the word repressed memory is not really in the sense of the question from the audience. I think there are tons of memories that you have in your brain that once you turn your attention to them, you can remember for sure. But I don't know that that's what we use as repressed.
I would make this, the terminology I would use, and I would make a difference about these two kinds of cases, is the non-scientific term repressed memory. That is someone who claims they've forgotten something happened and then 20 years later remembered it. I'm not saying it's not true at all, but I would treat that with special caution, I would say, because of the possibility that it's imagined, influenced, or implanted. I distinguish that very strongly from late report, which happens all the time, and in my view doesn't affect really the credibility at all. A woman who's raped and waits 2 months to go to somebody. A child who's molested and waits 2 years or 10 years or 20 years to come. Late report is very different. I don't have the same questions intrinsically about that memory, about the incident, but again, every case depends on the facts. Is it so old that I have no chance of getting a conviction? Any investigator, any prosecutor would want corroboration to assure themselves, too, that this is truly a true case and not revenge or something else.
Joey, last question. So you get the last question and the last word. What are your thoughts on the Woody Allen allegations?
Why'd you do that to me?
It's the audience who did it to you.
Oh, okay. I think you're touching on what I said before. If we're going to go into a situation where somebody's brave enough and courageous enough to come forward and said, I was molested or raped years ago, and we're going to automatically throw this blanket theory that repressed memory or whatever doesn't exist, you're going to, like the Woody Allen thing's a real good example. Do you know how many people that watched that were raped and molested will never come forward because they saw that? There's probably people out here, like I said, who are in that situation. What I think of it is she needs the burden of proof in a court or whatever to show that her memory is accurate. And it's up to the jury to decide. I stand in solidarity with anybody who's been accused wrongfully and was incarcerated, like the speaker before me. And she'll also tell you, though, that the majority of women in prison were abused. She said 85%, I think. So we owe it to society when somebody comes forward with something like that, not to tell them to shut up, you're having a bad memory, or you're wrong, you're guilty of lying before you've had your day in court. We owe it to them to listen to them. When I get calls from people that were sexually abused, I get a lot of calls from people that had repressed memory. Most of the calls I get about repressed memory are the wives of men who were abused, who remembered, just like the guy in Stockton, who were worried about their husbands, and their husbands didn't want to come forward, didn't want to report. They feel terrible. They're going through a psychological warfare and mess in their mind. And you know, it takes a lot of courage to come forward. And I think Woody Allen's daughter has a lot of courage to come forward nationally, because she's getting thrashed all over the internet. She's getting beat up daily, psychologically and emotionally, from a lot of people. And I think we owe it to her to listen to her story and to let her go through the process and find out if this is really true or not. I seriously doubt she came forward with this because her parents are getting divorced and she was pressured into it. I don't believe that.
Just a point of clarification, if I could, about the Woody Allen case. That is not a repressed memory case. Woody Allen's daughter claimed that he molested her from the day that she claims it happened. This isn't something that's come back to her 30 years later and several Academy Awards later. She made that claim at the time and continues to make that claim. That's different than a repressed memory.
Yeah, but she's still getting thrashed for it.
All right, thank you very much to our panel, Doug, Joey, Jim, Melina.